Well, good afternoon, everybody, and apologies for the slightly delayed start. The internet is generally broken today, I think, across the world, but we had a couple of technical issues. So we're running a few minutes late, and I'm just waiting. People are coming into the room. So I'm just, we'll just give it another few seconds to get a good number in. Okay, so I'm going to do a very brief introduction, given that we are behind time, and I just want to welcome everybody to this week's seminar, which is the second in a series entitled Status Check, 20 Years of the Equal Status Acts, organised by FLAC and Trinity College Dublin Law School. So this week's seminar is entitled Socioeconomic Status and Equality Law, and so as you'll expect, we'll be focusing on that socioeconomic status ground. For those of you who don't know me, my name is Fiona Donson. I'm a senior lecturer in the School of Law in University College Cork, and I'm also co-director of the Centre for Criminal Justice and Human Rights and director of a recently established Travel and Equality and Justice project, which is a joint project with FLAC funded by the European Union and which focuses on traveller access to justice with a particular emphasis on day-to-day discrimination. And we've got, unfortunately, slightly less than an hour. So I'm going to very quickly introduce our excellent panel of speakers and move straight into their presentations. We'll have 15 minutes per speaker, which should leave a small amount of time at the end for one or two questions, which I'll be delighted to moderate at that point. So I am absolutely delighted to introduce three really excellent speakers for today's session. They bring a range of different experience, which I'm sure will, by the end of the hour, bring you a rich understanding of this area. And first, we'll be hearing from Paul McKeon, who's an activist and will speak to this issue based on his lived experience. Paul is a higher executive officer in the Irish Human Rights and Equality Commission and an equality specialist. Driven by his own lived experience of socioeconomic discrimination growing up in inner city Dublin, his work and advocacy around the case for the inclusion of a socioeconomic status ground in Irish equality legislation, which he carries out in a personal capacity. And this has led to a commitment from the state for its inclusion in the programme for government in 2020. In 2021, Paul was one of the main rights holders that were consulted amongst a number of residents living in local authority flat complexes in inner city Dublin on how Equality Miscellaneous Provisions Bill 2021, which seeks to add the socioeconomic status to equality legislation, should be defined based on his own lived experience and examples. And then we will have Dr. Tamás Kádár, who is the Deputy Director and Head of Legal and Policy at Equinet, the European Network of Equality Bodies. He previously worked at the Hungarian Equal Treatment Authority as a legal officer, investigating discrimination cases and drafting decisions of the authority. And he's an experienced researcher and writer who has carried out research into the grounds and published on equality and non-discrimination. And he today will talk about the operation of this ground in a range of jurisdictions. And finally, we have Siobhán Phelan, Senior Counsel, who's a practicing barrister and a great friend of FLAC, having previously been the director and chairperson. And she practices primarily in the public law arena with a particular interest in human rights and equality law, and has lectured in the area of European human rights law. She will analyse the two bills for us today and give us a kind of in-depth understanding of what those draft pieces of legislation include. So with no further delay, I'm going to hand over to Paul with a reminder of 15 minutes, which isn't long enough, and I'll do my best to kind of keep a bit of a rein on things. Thank you.
Thanks a lot, Fiona. So essentially today, while I've done a lot of work around this issue, the exclusion of the social economic ground, what I'm here today to talk about is the lived experience and how the lived experience, not just from myself, but from people in my community, has just been exclusionary thing with the 9 grounds that we've never had a rights-based approach to address a lot of the discrimination we faced where other people on the 9 grounds would. So just to kind of give you a bit of background, I grew up in inner city Dublin, and with inner city Dublin dating back to the tenement times, and before that even with the poor laws, the deserving poor and the undeserving poor, was that when a lot of the tenements were knocked down, a lot of people were put into flat complexes. And I'm sure you're aware, like in the States, you had like what they called white flight. But in Ireland, in Dublin, you had a class flight. And a lot of the most poorest of the poor were left in the inner city. And a lot of us grew up in flat complexes. Now, when I grew up in a flat complex, for me, I never felt like in any way that I was disadvantaged. It was as I was growing up, I started to feel like how society was treating me, and a lot of the prejudice and stereotypes associated with coming from a flat complex, whether it was your address or your accent. So just when I was growing up, like we had the whole historic thing, and I was quite aware of it, that my grandfather, other people's grandparents as well, their uncles, my uncles as well, was that people were put into industrial schools for essentially being poor. The church was punishing them for robbing a bit of coal or robbing from an orchard, and people were sent away to the industrial schools. And as I was growing up, all the generation before me, all of my flats, there was always, in each household, someone had gone into prison. And like, I remember when the prison service used to keep the stats on it, it was over 60% of the prison demographic was coming from a cluster of streets in the inner city, in the south inner city and the north inner city. And that's a continuous revolving door. And just from growing up when I was a kid, I'd remember even to this day in how the police would socially profile you, and how the guards would come into the flat complexes and treat us. And the way you wouldn't see that treatment towards other people, like say the traveller community, certain ethnic minorities would have that similar treatment. But growing up in the inner city, it was a similar experience. And just to kind of start things off, just from when I was a kid, just from some kind of trivial things of even trying to go to the local swimming pool, I wasn't allowed to go to the local swimming pool. I had to get a reference, and my ma's reference wasn't good enough for them. That I had to go to the principal of my school to say that I was good character and I wasn't going to cause any antisocial behaviour. Now, when I was there swimming, because I was very into the football, but swimming was a good way of keeping active as well, I'd meet other kids there, and do you know, I'd say to them, like, did you have to get the work or did you have to get the reference to come here? And you'd be like, no, what reference? Like, and that was the first things I started kind of getting into mine. And then when I was playing football, getting into my teenage years, I remember becoming friends with a chap from Sandymount, and we played on a football team out in Ballyfermot for Cherry Orchard. I remember one day it was really hot out, and we were playing football in Ringsend Park, and we went over. He went over to get a drink in his house in Sandymount, so I walked over with him, and his ma ran out of the door when he came in and said, "Get that K word out of the garden. You've not to be hanging around with him." Now, I'd never been in trouble in my life, and I was stuck into football. I wasn't causing any trouble. And that was another thing, like, that I go back to, like, saying to my mom and my friends, and I was like, I'm not allowed to hang around with him because his parents won't let me near them. And even just as a teenage then, I'm sure you have all gone to teenage discos, was that we couldn't get into any of the teenage discos, and you had to change your school, you had to change your accent to say a word exactly you are from. And even just, I'm sure you all remember our graduation and how much of a great time it was for us, that essentially it's a milestone in people's lives. Well, a common thing that happens in the inner city with graduations is that we can't book for a Debs or a graduation in a hotel because it gets cancelled, and sometimes you have to get the teacher to book it. And what often happens, I remember even with my graduation, and this happened in the graduation with friends in Sheriff Street as well, the teachers had booked for the restaurant as a sending off to say thank you to the kids and wish them well in their career after school. And as the local families and the local kids that were finishing in the school was arriving, the bouncers were refusing them, and much to the teachers being horrified, like, they were all allowed in, but no one from the inner city, the families or the kids that went to the school, were allowed in. Now that's moved to where you're just having the graduation party now in the local community centre or in the local pub. And as I'm sure you have all seen now, the inner city now starting to get very gentrified, in that it's two worlds. It's the most poor living next to the most rich, and especially around the Docklands, it's very economically segregated, and it's gated communities living next to local communities and local flat complexes. A lot of services that have come into the inner city, a lot of businesses, are catering to that professional class and they don't want the local inner city community anywhere near their services. And I'll just give an indirect way of how they keep the local community out. So a lot of the gyms, and there's public gyms doing this, and now there's private gyms doing this. They will offer discounts, corporate discounts, discounts for employees, discounts in the universities as well. They offer discounts to the employees in the universities or the students as well. But the local community that's right next to them, that is disproportionately low income, and a lot of disproportionately it's lone parents as well. They need to pay the highest price, and they need to pay a joining fee. And you can only get that joining fee, and sometimes with the private gyms, it's over €500. You can only get that joining fee waived if you fit one of those groups. You come from one of the multinational company, or in terms of the universities offering those type of discounts, you're a student or an employee. So essentially the poorest are paying the highest. So that's a way they can kind of keep the local community out. And one similar to the traveller community as well is that going up to a nightclub, going up to a pub, being refused at the door. So before I get into one that happened to me recently with that, I'll just touch on an issue that happened with employment in 2015. I didn't have a leaving cert, and when I came back from Scotland, I was playing football. And I went back to education. I repeated my leaving cert, and I went into I got fee tack, and it allowed me to get into college through the back door. So I got into Blanchardstown, and from Blanchardstown I was able to get into Trinity College to get a postgraduate. So along this time as well, I was learning to speak Portuguese as well. So just that everyone in my class in Trinity and in Blanchardstown, they were moving quickly into employment. They were able to easily get into like internships as well, to where I didn't really know the system or how to get into any of them. So first, what was happening, I was trying to apply for graduate programs. Now, the graduate programs are very discriminatory in that you need to put down your junior cert results, your leaving cert results, and they also have internal employee reference scheme. Now, internal employee reference schemes, a traveller or someone from the inner city, or sometimes certain migrants from certain backgrounds, like if you take someone from the Black Irish community out in Blanchardstown, Turtlestown, they're not going to know people that's working in Facebook, or they're not going to know anyone that's working in PwC. So essentially, if you don't have the junior cert results, the leaving cert results, that employee reference scheme, the fact that you have the degree qualified for that role is only one of the 4 that they're marking on you before you even get to an interview. So a lot of people are getting, same as myself, I was getting cut off, and I just couldn't get through to where everyone I knew in Trinity College, they were all getting in, and I was near enough to about 1.5 years out of employment. And at the time I was learning to speak Portuguese, and I developed up to working proficiency level. And then one day, just I thought my luck was in, then a Portuguese guy that I knew who was teaching me Portuguese, he had said to me he worked for a whiskey company. And the whiskey company basically were looking for someone to go over to sell the brand of the whiskey in Brazil. And he said, you'd be a shoe-in for this, you're a native English speaker, and you can speak like what they call working efficiency level, which is advanced Portuguese. And you'd be selling the brand. And he was joking, you have the red beard, the red hair, you'd be a market success over there. So as part of the application, I had to make a video application. And when I was making the video application, you had to kind of sell yourself why you'd be an ideal fit. So I made the video application, submitted it. 2 months went by, didn't think anything of it. Eventually got the Dear John letter, thank you for your application, but at this time, unfortunately, unsuccessful. So I didn't think anything more of it. And then I think about a month after that, my friend contacted me, says, look, can I meet up with you? I says, yeah, no bother. So I met up with him, and then he was saying to me, I'm going back to Portugal. But here, look, when they were looking at your application, I was part of the assessment, and we were talking about your application on a WhatsApp group and your email. And it's common that we'd say a few jokes about some people if they're making a video and they're embarrassing themselves. But now I don't mean any way to be offensive in this word, but I think just in the setting that I'm explaining what happened in the lived experience, they start joking about me calling me a knacker, and they were joking as well that you'd be better off selling Dutch gold. And this was in a WhatsApp conversation, and there was someone else in the WhatsApp conversation who asked what a knacker was, and someone had ripped back then saying it's our version of white trash. Now, when I got that, he said to me, look, you can do what you want with this. I'm leaving the company and I'm going to work for a different company back in Portugal. So I had the correspondence, I had like the WhatsApp conversations, and there was email correspondence as well, which was more informal, just that he wouldn't be a business fit, and just kind of his presentation style and all. But the WhatsApp conversations was clearly using those derogatory terms. So I knew that I didn't have there wasn't a 10th ground, a social economic ground, because I was being treated unfairly on social economic status. But I thought, because the strength of it, and I went to my local TDs as well in the inner city, and they were completely outraged by it as well. And they says, like, this is something that, you know, they won't be able to refuse. But so I essentially tried to make the complaint, and it was it's literally ringing up to the customer information line and saying, like, trying to get through. And I was like, look, can I put this complaint through? And they were saying to me, well, essentially, you won't fit the criteria, so it'll be thrown out. And then I met with other people as well about it. And they says, well, you could go to the media about it, but, you know, Dublin's a small place, and, you know, if you're going to have to prove then how you got that correspondence, and then you could be putting, in terms of legal action, in terms of your friend who gave you the correspondence as well. So it was really heartbreaking, and it really brought home that whole thing around the 9 grounds, is that, you know, what happened to me is happening a lot of people. I was lucky enough that there was one time where I had direct correspondence and I still couldn't take a complaint. But just what I would say from what happened to me, from my own personal lived experience, people growing up in the inner city are very aware that equality is moving on the 9 grounds, and it's completely excluded us, despite the historic and the systemic discrimination and exclusion that inner city people face. And I don't want to keep mentioning about inner city people. This is happening in rural Ireland as well. It's happening out in Tallinn. But I suppose with the inner city, we're coming crashing up against gentrification, and it's always there, the complete contrast and differences, and there's always discrimination that's going on. But what I would say is that we can't, it's 2021 and we still don't have a social economic ground. And there has been an awakening in equality where we're advancing a lot of issues, and people have a rights-based approach to address the issues with day-to-day discrimination. They can take a case to the Workplace Relations Commission. And also, what's very important about this as well, even when we're collecting stats, there's obligations that we'll do on the 9 grounds, or if we're doing, essentially, if we're encouraging positive action across the civil service or in multinational companies, it's on the 9 grounds, and there's this uncertainty as well, can we do it on the 10th ground? And what you'll probably have seen lately, and it's got progressively worse over the last few years, is that we've moved completely into a 9 grounds approach in how we see inequality. And for people growing up in the inner city, we're seeing this as a hierarchy of equality, and there's a lot of tension in that. Can you imagine growing up in Sheriff Street and you're segregated by a wall for the multinational companies and the private gated communities, and equality doesn't even recognise you? And what's also frustrating is then you're not seeing civil society, or you're not seeing the important stakeholders who can make a change driving that. So just when I heard about this flak offend, that was why I felt I don't want to be sharing this to feel self-pity. I want to share this to wake people up to think, if we're pushing things on 9 grounds, we're not pushing it on another, just in terms of what issue that's creating, but also another issue we're creating where the 9 acts providing rights or accessing rights for people who fall outside the 9 grounds. So I'm just conscious of time. One thing I'll just finish up on is that this type of discrimination goes on indirectly, directly, every day in the inner city. The majority of the people that experience this don't understand the language, don't understand the rights-based approach, and when they get frustrated about it, sometimes people can belittle them and talk down about the experience they face. So what I would stress for a lot of people that are listening here today, and I'm sure a lot of people are here because they're passionate about human rights and equality. For myself, I never wanted to get into equality and human rights. I wanted to have a career. I wanted to get into when I got my degree. But this is something that affected me, and that's why I'm here today, to share my story and why I'm working in the area of equality and human rights. It's not something I particularly want to stay in to work, but from that experience I faced, I feel that we can't move really across human rights if we're going to exclude social economic status any longer. Because I'm sure you have seen kind of the tensions that's developed in the UK, where you have class inequality, you have race inequality as well, and sometimes they're pitted against each other. So that's another important aspect of why we need the social economic ground. And just the last thing, the social economic ground intersects in that if you take even the traveller community, disproportionately the traveller community probably would face social class discrimination on top of race discrimination as well, the most. So it is going to provide further protections for the grounds that's already there. So I'd like to hand over now, I think it's to Siobhán.
And I was Tamás, but thank you, Paul. You've set the bar high there in terms of timing. That was really excellent. Thank you. Brilliant. I'm going to move straight on to Tamás and give you the floor now. Thank you.
Thank you so much, Fiona. Setting the bar very high, not only in terms of timing, but also it's very hard to say anything after Paul's testimony. So I'm really glad to be here and to be able to speak to you about socioeconomic status as a discrimination ground. This is something that's also very close to my heart as a topic. I've written on this to the Equality and Rights Alliance back in 2016, which also shows that this debate has been going on for quite a while now. So I would like to start by saying, why are we even talking about a socioeconomic status ground? I think that after Paul's speech, it's not very hard to argue for having this discussion at least. But I wanted to say that everyone has a socioeconomic status, and it defines our experiences in life much more than we may think or would like to see, I think. And it's important to consider here such basic documents as the Universal Declaration of Human Rights, which starts by saying that all human beings are born free and equal in dignity and rights. Now, can we confidently say that this is the case and a homeless person or a child born into poverty really has the same dignity and the same rights in life as others? I'm not sure about that. Importantly, though, I think that poverty and other forms of socioeconomic disadvantage are not only an economic problem and phenomenon, even though some people would like to make it look like it's only an economic issue. Poverty and other forms of socioeconomic exclusion deprive people of their rights and the full inclusion into society, and they also result in a weak position to assert one's rights. We know from studies and the experiences of people living in poverty that discrimination leads to poverty and poverty leads to discrimination. So this is a vicious cycle, part of which can be tackled by introducing protection against discrimination on the grounds of poverty and social exclusion, or a socioeconomic status ground. It is useful to put a name on the issue and decrease social stigmatization of people living in disadvantaged socioeconomic status. Introducing a disadvantaged socioeconomic status ground is not only important in order to respond to discrimination that has already happened, but also to allow for the introduction of positive action measures, as Paul also mentioned, and equality duties, ensuring that policymakers take into account the equality impacts of all decisions on people living in poverty or social exclusion. Now, I would like to move on to my second topic, which is just reflecting a little bit on the COVID-19 impact on this. And in the field of equality in general, COVID-19 really acted, I think, in many ways as an eye-opener. At least we must hope so, that it opened the eyes of many. Equinet, the organization I work for, which is the European Network of Equality Bodies, we set up a database of complaints where our members were sharing with us what kind of complaints they received throughout the pandemic and related to the pandemic. And it shows the important role that a socioeconomic ground can play in addressing issues that arise during a pandemic and the resulting socioeconomic crisis. We already know that on average, over 20% of the EU's population lives at risk of poverty or social exclusion. And our members reported cases where this was made even worse during the pandemic. We heard about cases where citizens were denied a public service for not wearing a mask, when a mask was almost impossible to obtain and its price increased tenfold. We heard about a worker who was dismissed for inability to report to work in a context when all public transport had been shut off in the country or in the city and they had no other means to get to work. We heard about stores only accepting bank cards or credit cards, leaving stranded those that possess neither of these. And we also heard a lot about government emergency regulations, for instance, introducing curfews or other similar restrictions or shutting down public services, which did not take into account the particular socioeconomic situation and living conditions of certain groups and persons. Our reports on COVID-19 show that while we have talked a lot about different groups suffering particularly hard from the pandemic, socioeconomic status is clearly an additional and underlying vulnerability for all groups. In other words, while Roma, travelers, older persons, and persons with disabilities were proven to suffer disproportionately from the crisis, those among them who are in a disadvantaged socioeconomic status have suffered even more often. Socioeconomic status has therefore led to intersectional discrimination combined with many or all other grounds of discrimination. So therefore, Equinet found that, and I quote our report, that the grounds covered in the EU framework need to be expanded. In particular, the ground of socioeconomic status has come to the fore in the recent period, both in its own right and as an intersecting ground with grounds already covered. Quote end. So the next topic is, what do international, European, and national laws and practice tell us about these grounds? First, we have the UN level, where social origin, property, and birth are included explicitly in the International Covenant on Civil and Political Rights and in the International Covenant on Economic, Social, and Cultural Rights. And we also see the definitions of some of these grounds, which the UN Committee on Economic, Social, and Cultural Rights set out in their general comment number 20. So we have clear definitions on what these mean, and they are clearly covered by UN covenants. And the UN committees have also already discussed related issues in their casework. At the Council of Europe level, while the European Court of Human Rights hasn't yet explicitly recognized socioeconomic disadvantage as a discrimination ground, it has on a number of occasions already referred to the disadvantaged socioeconomic status of certain groups, such as in cases of segregation, school segregation of Roma pupils. Also at the Council of Europe level and in the framework of the European Social Charter, we have seen cases where complaints were brought because of evictions or lack of adequate housing, and the European Committee of Social Rights, which is the body overseeing the implementation of the European Social Charter, established a violation of the article providing for social protection against social exclusion and poverty, together with the non-discrimination article. So it was a violation of both. Moving on to the European Union, Article 21 of the Charter of Fundamental Rights of the EU, which is on discrimination, this article lists, among others, ethnic or social origin. It also lists property, and it also lists birth as grounds. At the national level, we also have plenty of examples. And you all know better than me that in Ireland already an amendment in 2015 introduced housing assistance or social welfare payments, receiving housing assistance or social welfare payments as a new ground into the Equal Status Act to protect against discrimination in accommodation. So it is currently limited to the field of housing, but I think it begins to open up a wider socioeconomic status ground, and this is very interesting. Now, just a couple of other examples from other countries. In Hungary, which is my native country, and that's where I worked with the equality legislation, there is a ground of social origin, and there is also a ground of financial status or wealth. And this has been in the legislation since its adoption in 2003. In Belgium, which is a country where I live now, The grounds of wealth and social origin are mentioned since 2007 in the legislation. And the annual report I just checked of the Equality Body from 2019 shows that 6.3% of all the complaints they received related to the ground of wealth or income. And this was the fourth highest ground. So it is not something that kind of is in the legislation, but is never gets to be used. In France, we saw in 2016 that they introduced in the legislation particular vulnerability resulting from economic situation as a new ground of discrimination. And other countries, I cannot even, I don't have the time to go into the details, but there are plenty of other countries where socioeconomic status ground is present in the Equality Body's mandates, such as Albania, Croatia, Cyprus, Latvia, Montenegro, Serbia, and Slovakia. You'll see that some of these are EU countries, some of these are accession countries. It's an interesting pattern that with the exception of Belgium and France, all the countries I mentioned are from the east of Europe. And I think this is a particularly interesting case where maybe the northwest of Europe really was the leader on equality legislation, and then Central and Eastern Europe, who started to adopt their legislation much later, they adopted it in a much more comprehensive way. So I think now the northwest of Europe maybe has some catching up to do. And these are just some examples where it is in the mandate of the Equality Body to deal with socioeconomic discrimination, but there are even more countries where legislation contains some sort of a socioeconomic status ground. The European Network of Legal Experts in the field of non-discrimination identified that equality legislation in 2015 included a socioeconomic status ground in 20 out of the 35 European countries they covered. And then I don't even go into the Canadian experience, where in Quebec, for example, the socioeconomic status ground has been in the legislation since 1975. And many provinces also adopted a socioeconomic ground in their legislation. But are they really used in their national legislation, you could ask? And in a survey to equality bodies, Equinet found that it is not necessarily easy. It takes some time to grasp how this particular ground can best be used. But once it's understood, then the value becomes evident. And we see that the number of cases received by equality bodies on this ground shows large variations, with some of them receiving no or very few claims, while others report that cases on this ground accounted for 25% of their casework. And this is across the different fields of life. We see cases in the field of housing, employment, education, the provision of goods and services, healthcare, the social protection systems seem to all generate casework. And as it was mentioned already, it quite often intersects with other grounds of discrimination. So the next topic I want to just very briefly touch upon is some arguments that are brought up against and in favor of a socioeconomic status ground. Now, first, we have to consider the international obligations of Ireland, of course, which I mentioned already. Then I have already stated that everyone has a socioeconomic status, and this clearly has an impact on their lived experiences. And we know that it might not be easy to define socioeconomic status. We see that in the Equality Bill, many different factors are considered to describe socioeconomic disadvantage, from poverty to regional accent, for example, and even leaving the list open. But it's, even if it is maybe difficult to define this ground, I would like to state that maybe there is a need and wide scope for judicial interpretation. This is not necessarily a departure from anti-discrimination law in general. It is enough to think about discrimination on the grounds of age or disability to realize that it isn't always easy to define what a certain ground actually means, or where can a situation and when can a situation be considered to have led to discrimination. Then some people bring up that socioeconomic status is not an immutable characteristic, But I think Paul also made a very powerful claim to show that, in fact, it is very difficult to change socioeconomic status of someone. Some others say that it's a policy and not a legal issue. So this, this is something that has to be addressed by social transfers and social policy measures, which to me is really a charity-based model, which I think we really have to go beyond, and we need to look at it with a rights and equality lens. And finally, because I think I'm running out of time, we need more data and information. So it's important that, for example, ATD Fourth World recently expressed in a document that they would like the Fundamental Rights Agency of the EU to carry out a Europe-wide study on discrimination on the grounds of poverty. And the last thing I want to mention is that Equinet, my own organization, we just initiated a research to be finalized by the end of this year on the need for and the added value of additional protected grounds into the equality legislation with a focus on socioeconomic status and health status. The topic and the focus on these two grounds originates from the experiences of equality bodies during the COVID-19 pandemic, where they saw that these grounds, where they were in the legislation, were really widely used. And this research is primarily targeting countries that haven't yet introduced the grounds or started discussions about introducing them. We are hoping to help these discussions. However, the Irish experience, where we know that discussions on the topic have been ongoing for at least 5 years now, is one that we hope to learn from, not so much have to influence with our study. That's all from me. Thank you very much.
Thank you, Tamás. That was great. So we've had two really excellent presentations, and we're moving on to our last, and we're doing brilliantly on time. So Siobhán, I'm going to hand very quickly over to you for our last session, or our last presentation.
Sorry, I'm just trying to figure out how to share my screen. Can you see my screen?
Yes. Yeah, it's perfect.
Okay, I don't seem to be. Okay. Good afternoon, everybody, and thank you very much to FLAC for inviting me to speak today on the topic of, I suppose, the legal basis for the introduction of a socio-economic protection in our discrimination legislation. And as everybody on the call is aware, and it's been touched on by other speakers this afternoon, we're at an important crossroads in the Irish context, in a circumstance where the inclusion of a socio-economic ground has been on the legislative agenda now since 2017, when the Equality Miscellaneous Provisions Bill of that year was introduced. Unfortunately, that bill fell with the fall of the Dáil, and a new bill, the 2021 bill, was introduced last January. And in looking at those proposed legislative measures from a legal perspective, I think it would be helpful to have some regard to the general legal situation in the state. And we will be aware that under Article 40 of the Constitution, there is protection for equality rights and protection against discrimination. I have it there on the screen, and you can see that in its terms, it is a provision that is capable of being far-reaching, but it is of course subject to the interpretative approach taken to it. And the jurisprudence under the Constitution has shown that, in fact, the main protections that have been developed in Irish law in respect of discrimination and equality rights has come through legislative change, and hasn't been driven by the approach taken by the courts to Article 40, subparagraph 1 of the Constitution. And in turn, our legislative provisions, and principally we have the Employment Equality Acts introduced in 1998 and the Equal Status Act introduced in 2000. In turn, these have been driven by international situation and the European situation. And we know, for example, that our Equality Acts were largely driven by the external requirement to meet our international obligations under the Convention on Women's Rights, the UN Convention on Women's Rights, and the UN Convention on Racism. And I have listed here just the existing grounds that are covered under the legislation, the existing 9 grounds. No new ground has been added since the introduction of the legislation, but there has been an additional ground of discrimination in relation to the provision of accommodation services to those who are in receipt of social welfare payments, and that was introduced by the 2015 Act and has been referred to by other speakers. And I suppose it's an important change in that it shows already that through legislation we are moving towards providing protection, albeit in that limited fashion, in respect of socioeconomic discrimination. Given the importance, though, of external factors as a driver for change here, as we've seen already through the provisions that have been adopted, I suggest that it is useful to see where that impetus is coming from at this time. And Tamás has referred to the various international and European instruments that protect social origin, social status in various forms. I suppose I just point specifically there on the list to the European Convention on Human Rights, which under Article 14 protects social origin and other status. So it's a very wide-ranging definition. Now, there are limitations in respect of Article 14 because of the need to interpret it in conjunction with another substantive convention principle, convention protection. But we have seen that, we've seen through the jurisprudence of the European Court of Human Rights that the manner in which Article 14 can be relied upon increasingly to address discrimination in relation to social origin and other status. And the other provision I'd flag just specifically of these measures is Article 21 of the Charter, because of course the Charter is given particular force in our domestic legislation before the courts here because of the force of law that's given to the requirements of the EU legal system. And whilst the Charter may be limited to areas that fall within the scope of operation of EU law, we know that that's becoming an increasingly large field of operation as time passes. So potentially it will in the future be a very important driver for change, given the manner in which it seeks to protect social origin and property, for example, within the ambit of Article 21. Now, other drivers for change, this has been touched on by both Paul and Tamás. It is the case that Irish protection of against inequalities, the protection against discrimination has perhaps and is now seen as being out of kilter with the lived experience of discrimination. And I have there on the screen an extract from Kate Mallison's writings on this subject, where she talks about the change in how we experience inequalities and how we understand and perceive inequalities, to the reality that nowadays, because I suppose in part because of the success of other measures that have been taken, but nowadays the most determinative fact in relation to most people's life chances is their socioeconomic origin and status. And so if our legislation is to be effective in protecting against discrimination and promoting equality, it has to move in tandem with that lived experience for most people. And separately, we have the growing need to address intersectionality and a growing awareness of the impact of intersectionality and the link with socioeconomic disadvantage for other of the protected grounds. And so these are factors that are driving and the change that I think is now accepted must happen in order to bring our anti-discrimination legislation to a state of fitness for purpose in the 21st century. And we see this, and here I have on the screen just a quote from a study done for the Equality Authority, for the Department of Justice back in 2004, where those two principles are encapsulated neatly: this need to reflect the lived experience and also the need to promote a more sophisticated intersectional approach to discrimination. There have been, I suppose, before we move to look at the proposals, the particular legislative proposals, there have been other pieces of legislative reform which I suggest impact in providing protection of socioeconomic disadvantage in the Irish context since the equality legislation was introduced. So we have the European Convention on Human Rights Act in 2003, which under Section 3 imposes a duty on public authorities to perform their functions or to discharge their functions in a manner which vindicates convention rights. And that, of course, brings into place not Section 14, but Article 14 of the Convention insofar as it protects social origin and other status. We've got the provision of the 2015 Act, which we've already referred to in relation to discrimination on grounds of the receipt of housing assistance. And then quite importantly, and I think relevant to this wider debate, we have the provisions of specifically of Section 42 of the Irish Human Rights and Equality Commission Act of 2014, which is, I suppose, more commonly known as the public sector duty. And why Section 42 is relevant to this debate is if you look at the duty that is created, and the first element of that duty is to eliminate discrimination, B, to promote equality of opportunity, and C, to protect the human rights of members and staff and persons to whom services are provided. Now, looking at each of those provisions, if you look at B, for example, A, and the definition of discrimination, if you go to look at the discrimination section of the 2014 Act, you see that it is tied with the equality legislation. And so the addition of a socio-economic ground to our equality legislation as a ground that requires protection would in turn bring into play the Section 42 duty, the public sector duty. There is an argument to say, however, that it is already there, it's already protected to some extent, because under C here, we have the obligation of public authorities to have regard to human rights that are already protected in Irish law, which would include rights protected under the European Convention of Human Rights. But there is, you see, if you look at the second element to Section 42, is how it I suppose sets out specific measures that the local authority must take in order to discharge its duties under Section 41. So there's Section 42. So there's a very specific tasks that the public authority must do, and these tasks are directed towards requiring public authorities to think about socioeconomic disadvantage in the way they perform their duties and carry out their duties, and in thinking about them and in addressing them, taking steps to tailor their service provision or the manner in which they carry out their duties to vindicate and respect socioeconomic rights where they are encapsulated or included. So the importance of Section 42 of the 2014 Act, in this debate, I think requires being stressed, because if you look at the difficulty with socioeconomic protection in other countries, what is reported is that it hasn't been as effective as it might be because of this need to rely on individual rights and to engage in litigation. So an enhanced role for a public sector duty goes a long way towards addressing that, because you have a greater focus on systemic change and on public bodies developing a culture of positive change and positive action. It's perhaps interesting to note as an aside that public sector duty in relation to socioeconomic rights was provided for under the 2010 Equality Act in the UK, and it is in operation in respect to Scotland and Wales, but has not yet been given effect to, hasn't been commenced in respect of England as of yet. So it's against this general background that we've had two pieces of legislation, the 2017 bill and the more recent 2021 bill. There was a commitment given in the programme for government in 2020 to examine the introduction of a new ground of discrimination based on socioeconomic disadvantage. And so we're at a crossroads in that there seems to be a large body of support at a political level for the introduction of these measures. Now, when you look at the two bills, their purpose seems to be largely the same. And I've just set out there extracts from the explanatory memoranda, which shows that the intention behind the measures is pretty much identical, although they go about achieving it in a slightly different way in the manner in which provision is then made. And so you have two different, I suppose there are two essential differences between the two measures. One is in relation to the definition of socioeconomic disadvantage, and the other is in relation to the discriminatory ground and how it's phrased. So if we look here at the definition, you see in the 2017 legislation, there's a tighter definition. You have disadvantaged socioeconomic status means a socially identifiable status resulting from, and you have a number of listed characteristics. And then in 2021, you have a definition which is a more open-ended definition. It identifies instead indicators of socioeconomic disadvantage. And just if you look at that, the 2021 definition, I think it'd be fair to say that broken down, there are 4 elements to the test. To bring themselves within that definition, an individual would have to show that they were included in a socially identifiable group. They'd have to show that it was other than on a temporary basis. They would have to show that the group either suffers from social disadvantage or economic disadvantage, and that the difference in treatment resulted from one or more of the factors that are listed from A to G. It's clear that it's difficult to define what is meant by socioeconomic disadvantage, and that's even illustrated, I think, by the two different definitions that we see reflected in the 2017 and 2021 Act. The other difference, as I say, is in relation to the definition of discrimination. The 2017 Act defines the difference as being that one has a disadvantaged socioeconomic status and the other has not, whereas the 2021 bill talks about one having a socioeconomic disadvantage and the other not, or alternatively, a person with a different socioeconomic disadvantage. So the 2021 definition permits intersectionality as between different grounds in a way that is not so clearly open under the 2017 definition.
Owen, I'm really sorry to be interrupting, but we're now at 2. Can I ask you to, because I really would love to keep on hearing this detail, but we're closing on time pretty quickly now.
Thanks, Fiona. I'll try and wrap up. On this slide, we just see other differences between the legislation, which are really consequential changes that will be made to integrate the socioeconomic ground throughout the bill. Notably, neither of the drafts deal with more issues, greater issues or more fundamental issues dealing with the scope of the legislation. So, for example, there's no attempt made in these amendments to ensure that all public services come within the definition of services. So there may still be important areas outside the scope of the legislation, even with the amendments introduced. There's no proposal to amend Section 14 of the legislation. And so those are material issues that will affect the I suppose, effectiveness of the legislation going forward. The two main criticisms of the proposal when it was introduced in 2017, taken from the Dáil debates, was firstly this lack of precision or clarity in relation to the definition. And then there was a concern that it would lead to an increase in claims. And I suggest that these issues are not as significant as perhaps they might at first blush appear. And if you take, if you change your perspective to what the purpose of anti-discrimination legislation is, to being directed towards dealing with the effects of discrimination, where different treatment is driven by stereotypes, that it becomes easier to work with the definition that's found either in the 2017 version or the 2021 version. So I suggest that what's required when grappling with definitional issues is that one looks at what the purpose of the legislation is rather than how it's phrased. And when we look now at the different academic writers on this area, we see a move away from immutability as a feature. We see a move towards anti-discrimination law being concerned with illegitimate social bias, and also a move towards an identification of an effects-based approach. And this is an approach that I suggest is already present in the in our equality legislation. And there's an extract there from Quinlivan and Bruton explaining that our legislation has already adopted a purposive approach. The second criticism was that of floodgates, and I think that is to ignore the difficulties that are documented as existing in relation to establishing a successful equality claim in the first instance. So a proper appreciation of what one has to do to establish a discrimination claim deals with, I suggest, the floodgates concerns. So then just setting out some conclusions here. And I'll finish on that. Thank you.
Thank you. That was excellent. Thank you, and a real insight into the legislation, which hopefully we'll see some movement on. We've got one question, and I know we have virtually no time, but there's one question that has come up that I think might tie things together a little bit in terms of waiting for the legislation. And it was popped into the questions quite early on, which was, in the absence of legislative change at the moment, does the inclusion of socioeconomic status in the development of policy and in development of how we, how public bodies respond to things, does that help in terms of moving forward? And I think possibly all three of you have kind of commented on that, but if you want us to kind of say something else, because obviously we are in that space of waiting and hoping and seeing a good piece of proposed legislation coming through. So Paul, yes, please.
Yeah, just I'll try to be fast as possible. So essentially, just because it's not in the 9 grounds doesn't mean then that policymakers, civil society is just like, oh, well, we can't do anything on it. If we're pushing, like I've seen some departments now have added social economic ground to their equality statement, and some private multinational companies as well, and the Access programme as well. It's positive action on a social economic ground for disadvantaged students to get into college. But also, if we're recording data, so the British Civil Service now released a report only 2 weeks ago, and they use measurements and indicators of the social economic profile of the British Civil Service, and they're still moving on, and that's given evidence as well to show, look, this is where we're falling down. And it did find, the British Civil Service study, that people from basically working class, lower social economic, white working class basically, and Black Afro-Caribbean were the 2 most underrepresented groups in the British Civil Service. Now that's adding evidence then essentially to the whole fight to get the social economic ground in. So I would argue that it just there is some reservations though. Some people say, oh well, if it isn't in the 9 grounds, and sometimes it can be used as an excuse, but evidence shows that it can still be done as a positive action measure.
Thank you. Anyone else want to come in? Tamás?
Yeah, just very quickly. I agree with Paul. Of course, it is possible. Coming from the country where I originate from, I would be afraid that if it's not in the legislation, it's very easy to do something and then just backtrack on that. And when there is a change of government or there is a change of company leadership, then they just completely change course and forget about it. So I think I would see that as a guarantee. And I do believe that policy can reach a lot, but you need to have a sharp legal tool and in the background as well. And the other thing is that I think if we focus only on policies, then that risks to go down towards the charity-based model that I mentioned.
Thank you. Siobhán?
I would echo that, and I suppose the effect of introducing a socio-economic ground and having it included as part of the positive public sector duty, for example, is that it proactively causes public bodies in particular to think about the impact of socio-economic disadvantage in how they go about their work. And it's that incentive to actually address the issue that is required. So just leaving it as a policy matter perhaps doesn't get the follow through that's required, but actually legislating for it will have the spin-off effect of raising awareness and consciousness, which ultimately will be the driver for change, I suspect.
Thank you. It's kind of sad to have to bring this to such a swift conclusion. I think one of the key things that all of you have talked about today is intersectionality and the reality of discrimination, lived experience. And Paul, the way you started today's session was very powerful and right on point, and gave us a really important context to understand what the law should mean and how it can make a difference. And yes, policy is only one part of the picture. So I want to say a huge thank you to all 3 speakers. Such really informative and powerful kind of statements about the importance of this. I've been delighted to sit here and listen and learn. And as I say, we could, I'm sure, carry on listening and talking about this for much longer, and we will need to, and it needs to be kept in the public eye. So thank you, Paul, Tamás and Siobhán. And thank you, FLAC and Trinity College for organising this. Just to remind everybody that there's more coming. These have already been a great series of seminars. So a week on Wednesday, the next FLAC Trinity seminar is on the evolving equality architecture. So that's Wednesday rather than Tuesday, but please join us. And I understand that it's been recorded and it will be uploaded so people can watch back and learn more. So thank you, everybody.